Hello, my name is Loveleen Bhular and I will be presenting the module Principles of Environmental Law. The objective of this module is to introduce you to three ideas: the concept of sustainable development, the precautionary principle or approach, and the polluter pays principle. Let us begin with sustainable development. As early as in 1962, a United Nations General Assembly resolution encouraged governments to pay attention to natural resources management early into a phase of economic development. This thought continued into the Fornix Report of 1971, and in the year 1972, the Stockholm Declaration, one of the main outputs of the United Nations Conference on Environment and Development, called on states to adopt an integrated and coordinated approach to their development planning so as to ensure that their development is compatible with the need to protect and improve the human environment. This was followed in the year 1980 with the World Conservation Strategy, which identified the need for integration of conservation and development to ensure that modifications to the planet do indeed secure the survival and well-being of all people. As we can see, indirectly, each of these instruments is highlighting the concept of sustainable development, although the term itself is not specifically employed. In the year 1987, the Brundtland Report, or the report also known as Our Common Future, defined sustainable development as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. The idea which is highlighted here is the idea of needs, and this is a reference to the essential needs of the world's poor being an overriding priority. There is also a concept of limits which are not absolute, and the report also highlights the interaction of present state of technology and social organization on natural resources and the ability of the biosphere to absorb the effect of human activities. The concept of sustainable development was then included in the Rio Declaration of 1992. A number of principles of the Rio Declaration reference this idea. For example, Principle 1, which states that human beings are at the center of concerns for sustainable development and that they are entitled to a healthy and productive life in harmony with nature. Principle 4, which states that in order to achieve sustainable development, environmental protection shall constitute an integral part of the development process and cannot be considered in isolation from it. Also, we have Principle 3 of the Rio Declaration, which states that the right to development must be fulfilled so as to equitably meet developmental and environmental needs of present and future generations. What we see here is a clear link being drawn between economic development and environmental protection, keeping human beings at the center of this discussion. In the year 2002, one of the main outputs of the World Summit on Sustainable Development held in Johannesburg, South Africa, was the Johannesburg Declaration on Sustainable Development, and it states, and I quote, "We assume a collective responsibility to advance and strengthen the interdependent and mutually reinforcing pillars of sustainable development: economic development, social development, and environmental protection at the local, national, regional, and global levels." We see here a move further from the discussion being restricted to economic development and environmental protection, with the inclusion of social development as the third pillar of sustainable development. One of the few instances where the concept of sustainable development has been considered by the International Court of Justice is the 1997 case concerning the Gopčíkova-Nagymaros project. The parties to this case were Hungary and Slovakia, and the case concerned a treaty to build a series of hydroelectric dams on the river Danube. Both of the parties, Hungary and Slovakia, referred to sustainable development in this case, and the ICJ noted this need to reconcile economic development with protection of the environment is aptly expressed in the concept of sustainable development. For the purposes of the present case, this means that the parties together should look afresh at the effects of the environment of the operation of the Gabčíkovo power plant. What is also of note in this case is the separate opinion given by Vice President Veeramantri, who noted that the right to development does not exist in the absolute sense. It is relative always to its tolerance by the environment. According to him, right to development is clearly part of modern international law, and this is compendiously referred to as sustainable development. Another decision of the International Court of Justice from the year 2006 is the pulp mills case Provisional Measures. The parties to this case were Argentina and Uruguay, and this case, according to the ICJ, highlights the importance of the need to ensure environmental protection of shared natural resources while allowing for sustainable economic development. According to the court, it is necessary to bear in mind the reliance of the parties on the quality of the water of the river Uruguay for their livelihood and economic development, and account must be taken of the need to safeguard the continued conservation of the river environment and the rights of economic development of the riparian states. The Supreme Court of India has also applied the concept of sustainable development in a number of cases over the years. While in the late 1980s, the approach of the Supreme Court was a compromise approach in disputes concerning termination of mining leases, during the 1990s, the Supreme Court adopted a more environmental focus. More recently, there has been a shift towards an anthropocentric or ecocentric basis of sustainable development. The Article 21 right to life has been read broadly by the Supreme Court to include the right to environment and the right to development. In a 1991 decision of the Supreme Court in the case of Rural Litigation and Entitlement Kendra versus State of Uttar Pradesh, the Supreme Court observed that if a just balance is not struck between development and environment by proper tapping of natural resources, there will be a violation not only of Article 21 but also Articles 14, 48A and 51G of the Constitution of India. One of the important decisions in this regard is the case of Vellore Citizens Welfare Forum versus Union of India and others, a 1996 decision of the Supreme Court. This case arose in the context of a suit in response to reports that tanneries were discharging effluents into the river Palar in the state of Tamil Nadu, where this river was a main source of drinking water supply. The Supreme Court made a number of observations with respect to sustainable development in this case. For example, it noted that the traditional concept that development and ecology are opposed to each other is no longer acceptable. According to the court, sustainable development has been accepted as a part of customary international law, though its salient features have yet to be finalized by the international law jurists. Supreme Court also identified certain salient principles and essential features of sustainable development, such as the precautionary principle and the polluter pays principle, both of which will be discussed in the course of this presentation. Finally, the Supreme Court noted that notwithstanding the economic benefits of the leather industry, which was responsible for the discharge of these effluents, economic interests cannot be allowed to destroy the ecology, degrade the environment, and pose a health hazard to the public at large.